At 4:12 this afternoon, the High Council voted 41 to 26 to invoke Article 9 of the federal charter. The threshold required was 38 votes. The presiding magistrate announced the result without elaboration. The council had exercised a constitutional power that exists in text, but had never been tested in practice. The federal executive, currently holding office under emergency provisions enacted 11 months ago, had been formally declared in violation of charter authority. The council vote triggered a mandatory transfer of executive function to the deputy executive within 6 hours. At 4:29 p.m., the executive's office issued a one-sentence response. The vote is noted, but does not alter executive authority during the declared security emergency. Subscribe to this channel now, because what you are about to see is not a political dispute. This is a constitutional mechanism activating without a clear enforcement pathway. This is two branches of government asserting contradictory interpretations of charter law. And this is the Federal Protection Service, the National Defense Command, and the judiciary being forced to choose which authority to recognize. Turn on notifications, because the next 12 hours will determine whether charter provisions can compel compliance or whether executive refusal renders constitutional power symbolic. Here is what led to this moment. 11 months ago, the executive invoked emergency security protocols following coordinated attacks in the Northern Industrial Corridor. The charter permits temporary expansions of executive authority during verified security crises. The emergency declaration suspended certain legislative oversight mechanisms and granted the executive direct operational control over federal enforcement agencies. It also extended the executive's term, which had been scheduled to end 4 months ago. The High Council authorized the emergency declaration by a vote of 52 to 15. But here is where it shifted. 3 months ago, the Internal Security Directorate detained 6 opposition parliamentary bloc members on suspicion of coordinating with external hostile actors. The detentions were conducted without judicial warrants. The detainees were held in federal facilities without legal counsel for 41 days. The High Council's Oversight Committee demanded their release. The executive refused, citing national security. The Superior Tribunal issued a binding order requiring immediate release and access to counsel. The executive did not comply. On the 42nd day, the tribunal declared the executive in direct violation of Charter Article 6, which prohibits detention without judicial authorization. At point, the constitutional system entered uncharted territory. The tribunal had ruled, the executive had defied the ruling, and the High Council had done nothing. For 6 weeks, the situation remained frozen. The 6 detainees were eventually released after external diplomatic pressure. But no acknowledgement of the tribunal's authority was made. The executive's continued invocation of emergency authority, now 8 months beyond the original 4-month authorization, raised the question of whether the emergency protocols had become permanent. Now watch what happens next. 2 weeks ago, 3 High Council members from the governing coalition submitted a formal motion under Article 9. The motion stated that the executive had violated charter provisions by defying the tribunal's binding orders and by extending emergency authority beyond constitutional limits without renewed council approval. Article 9 permits the council to declare an executive in violation and to transfer authority to the deputy executive if 2/3 of the council concurs. The motion was procedurally valid. It triggered a mandatory closed session vote. That vote occurred this afternoon, and 41 council members voted to invoke Article 9. The deputy executive, who had remained publicly neutral throughout the crisis, was sworn into executive function at 5:03 p.m. by the chief magistrate of the Superior Tribunal. The oath was administered in the tribunal's main chamber. It was not conducted at the executive residence. The reason is that the executive, whose authority was declared void by the council vote, is currently occupying the executive residence and has issued no indication of departure at 5:18 p.m. The Federal Protection Service, the security detail assigned to protect executive authority, issued an internal directive. The directive stated that protective resources would be allocated to the individual holding lawful executive authority as determined by charter procedures. The directive did not specify which individual that was. At 5:34 p.m., the National Defense Command held an emergency briefing with senior operational commanders. According to sources present, the Defense Command's legal counsel stated that Article 9 transfers are constitutionally binding and that command authority follows the deputy executive as of the council vote. No formal directive was issued to all military personnel. At 5:47 p.m., the executive's office released a statement. The emergency security protocols remain in effect. Executive authority continues uninterrupted. The Council's procedural vote does not supersede emergency provisions enacted under Section 14. All federal agencies are directed to maintain current operational command structures. Drop a comment right now. Tell me who holds executive authority: the individual removed by council vote who refuses to acknowledge removal, or the individual sworn in by the tribunal under Article 9. I am reading every response because this is the question every federal employee, every protection service agent, and every military commander is asking themselves tonight. At 6:02 p.m., the deputy executive, now claiming constitutional authority as executive, held a press conference. The charter has been followed. The High Council exercised its Article 9 authority. I have taken the oath of office. I call on all federal personnel to recognize the constitutional chain of command. I call on the former executive to respect the Council's decision and to vacate the executive residence immediately. That statement establishes that the new executive views the former executive's continued presence as unlawful, but it does not clarify what mechanism exists to enforce departure if the former executive refuses at 6:29 p.m. The Federal Protection Service Director was asked directly by reporters which executive the service is protecting. The director stated that the service protects the office of the executive as defined by the charter. The director did not state which individual currently holds that office. Subscribe now if you have not already, because what I am about to show you is how enforcement authority fragments when two individuals claim the same constitutional position. The Federal Enforcement Bureau, which operates under executive authority, issued no statement. The director of the Bureau was appointed by the current executive under emergency protocols. That director has not resigned. The Bureau's field offices received no directive clarifying which executive to report to. At 7:14 p.m., the Superior Tribunal issued a clarification. Article 9 transfers are immediate and binding. The Council vote at 4:12 p.m. transferred executive authority. The individual sworn in at 5:03 p.m. is the lawful executive. The individual occupying the executive residence no longer holds constitutional authority. That clarification establishes the tribunal's position. But the tribunal has no enforcement mechanism. It can declare what the charter requires. It cannot compel compliance. There is a detail most people missed. The federal charter includes no provision specifying how to remove an executive who refuses to recognize a lawful transfer of authority. Article 9 establishes the Council's power to declare violations and transfer authority. It does not describe what happens if the removed executive simply remains in the executive residence and continues issuing directives. The framers of the charter assumed compliance. They did not design an enforcement mechanism for refusal. At 8:03 p.m., the High Council reconvened. A motion was introduced to authorize the Federal Enforcement Bureau to facilitate the departure of the individual occupying the executive residence unlawfully. The motion required a simple majority. It passed 39-28, but the motion did not specify which officers would execute the removal or under whose command they would operate. At 8:47 p.m., the former executive posted a message on official communication channels. The emergency security protocols enacted under Section 14 grant the executive expanded authority during verified threats. Those protocols remain active. The Council's vote does not terminate emergency provisions. I continue to hold executive authority under emergency law. Federal agencies will maintain current operations. Any personnel who abandon their posts or refuse lawful orders will face disciplinary action under security regulations. That message reframes the dispute. The former executive is not claiming the Council vote was procedurally invalid. The argument is that emergency authority supersedes Article 9 transfers at 9:12 p.m. Constitutional scholars were asked whether emergency provisions override Article 9. The consensus was that emergency authority expands executive power but does not nullify charter mechanisms for removal. But no court has ever ruled on this question because no executive has ever invoked emergency authority to resist a Council-ordered transfer. This is the moment it stopped being a procedural disagreement and became an enforcement crisis. At 9:34 p.m., the Federal Protection Service split. 7 agents assigned to the executive residence detail left the premises and reported to the new executive's location. 11 agents remained with the former executive. The director issued a statement at 9:51 p.m. Protection Service personnel are reminded that their oath is to the charter, not to individuals. Agents are directed to protect the lawful holder of executive authority as determined by constitutional process. Agents who refuse lawful directives will be subject to immediate suspension. But the statement did not clarify which executive is the lawful holder. And agents on the ground are making independent judgments about which authority to follow. At 10:18 p.m., the National Defense Command issued its first formal directive. Effective immediately, operational command authority is vested in the individual sworn in as executive under Article 9 procedures. All military personnel are to recognize the constitutional chain of command. Orders issued by individuals not holding lawful executive authority are not binding. The military has chosen. They are following the new executive, but at 10:47 p.m., the former executive issued a counter-directive. Under emergency security protocols, military command operates through the National Security Council, which I chair. The Defense Command's directive is unauthorized and void. Commanders are directed to maintain current operational posture. Any deviation constitutes insubordination under military law. Here are the indicators we are watching over the next 24 hours. Does the former executive leave the residence voluntarily? Do Protection Service agents stand down? Do military commanders comply with the Defense Command directive or follow the counter order? Does the Federal Enforcement Bureau clarify which executive it reports to? Do allied foreign governments recognize the new executive? Does the High Council authorize use of force if necessary? Here are the 3 scenarios. Scenario 1. The former executive leaves within 24 hours. Faced with institutional isolation and military noncompliance, departure occurs without confrontation. This is the compliance scenario. Scenario 2, the former executive is removed by federal enforcement. The new executive orders removal, Protection Service agents stand down, and departure occurs under duress. This is the enforcement scenario. Scenario 3, the former executive successfully resists. Protection Service agents refuse to stand down. The Federal Enforcement Bureau does not act, and the military splits. The government operates with competing executives. This is the fracture scenario. Let me show you why this has never happened. The federal charter has been in effect for 132 years. Article 9 has been invoked twice before. In both cases, the executive resigned before the council vote concluded. There has never been a completed Article 9 transfer where the removed executive refused to acknowledge removal. What I know for certain right now, the High Council voted 41-26 to invoke Article 9 at 4:12 p.m. The deputy executive was sworn in at 5:03 p.m. The former executive remains in the executive residence and claims continued authority under emergency provisions. The Federal Protection Service is divided. The National Defense Command has recognized the new executive. The Federal Enforcement Bureau has issued no directive. And the Superior Tribunal has clarified that the new executive holds lawful authority but possesses no mechanism to enforce that clarification against physical resistance. The constitutional system has spoken. Enforcement will determine whether it can be heard at 11:34 p.m. The official charter archives recorded the following entry: Article 9 invoked. Executive transfer declared, lawful authority contested, enforcement status unresolved, and the next entry in that archive will record whether constitutional authority prevailed or whether it was tested and found unenforceable.